All right, we're going to get a break. First, let's bring in Jamie White. He's in East Lansing, Michigan, trial attorney there. Jamie, what's your take on this one? You've got this convenience store owner. He's on the stand. He's been in the community for 20 years, as he testified to. He's a part of the, basically, the business owner group that's been there for, and he's aggressive in the confrontation, and we've seen a little aggression here in the cross-examination as well, getting his buttons pushed. What are you taking away? What stands out to you?
Well, I think Cross has been effective in the sense that this particular defendant has to show that he reasonably believed that his life was in harm's way. And it appears that his strategy, at least in part, is to suggest that he thought there was something deadly in this bag. I think most reasonable people would avoid a confrontation involving that bag as opposed to continuing to try to confront the individual with it. We've seen this play out in multiple venues. I'm in an area that's surrounded by Division I universities. We see it in a bartender bouncer situation on a frequently basis, and you cannot defend property with deadly force. And he initially approached this defendant and ultimately used deadly force for really the purposes of protecting property. There doesn't appear to be any evidence that a reasonable person would find himself in harm's way, certainly not in a deadly consequence.
Is it wrong for him to say, hey, I saw you steal on the camera, give me my Gatorade back?
That in of itself in a vacuum, there's nothing wrong with that. I think that retailers do that all the time. Where he went wrong is where he obstructed the victim in this case from leaving the store. You know, I've seen cases where people were charged with crimes simply for locking the door and keeping someone you know, against their wishes, even if in fact they were committing a crime. Here we clearly have a misdemeanor offense. It wasn't violent in nature, and so outside of telling the young man to return the item or stay until the police come, that's really where his legal boundaries lay, to not break the law. And he went so far beyond that. I'll be shocked if the jury does not convict him of second-degree murder.
All right, let's get a break. We'll pick up the more of the cross-examination, and then there'll be a little redirect as well, all taking place in North Carolina. The defendant, Taz Zarka. Stay with us. But that is obviously what happened. The 27-year-old customer ended up dead after being stabbed by the owner, Jamie White. Your thoughts? He is, because he's been on the stand for so long, you kind of got to, you know this guy, right? And the jury is getting to know him in a way that you would never know him if he was just sitting over there at the defense table. And that can go one way or another. But what about what do you think of the theory that him taking the stand could really help his cause, because it's been taking a long time. This started yesterday, it's gone on all day today. Could he be connecting with a member of the jury, maybe an older member of the jury, maybe someone who is sick and tired of these, you know, that theft, that mentality, a business owner, something like that?
Well, to the first part of your question, you know, in a self-defense case, you know, similar to an alibi case, it's almost a requirement that the defendant take the stand. You know, the unique thing about this case is where we don't see a prerequisite the defendant take the stand is often when we have witnesses and video, which we have in this case, and the defense still found it necessary. And I think that speaks to the strength of the evidence of the prosecution. As far as the second part of your question, Ted, man, you know, we've been doing this a long time. I mean, you never know, right? I mean, it only takes one. I think that the prosecutor maybe got a little off the beaten path when you start talking about price gouging and, you know, different things that, in my opinion, are not relevant. With that said, you know, I think the jury instructions are going to be very, very clear. And, you know, I think his behavior was unreasonable under the circumstances, and while he has been up there for quite a while, he appears to be contradicting himself, making up things as he goes. And I think more importantly, he's becoming argumentative and not willing to specifically answer the questions that are asked of him. And there will be a jury instruction that speaks to specifically that issue. Was he being cooperative or was he being evasive? And I think the answer in some part, if not a significant part, is evasive.
Yeah. It's interesting the prosecutor's not recuing the tape and, you know, doing it from his, because they got to watch it all from the defense, and yes, it was a bit mind-numbing because it went on forever, but I would be rolling this thing and saying, weren't you mad right now? Weren't you? I mean, well, you're walking on and doing it that way so that the jury can see the same video in a different light. It's just, he's kind of just leaving it to the defense's narration of this video, which might be a mistake. We'll see. Let's get a break. We'll get you back in for more of this back and forth between the defendant and the state. Okay, Taz Zarka, the defendant's very aggressive on the stand, basically kind of taking over a little bit of the cross-examination. Jamie White, your thoughts there? He's getting more comfortable, which could hurt him.
Yeah, going back to the last segment, I think we're looking at a situation where he's becoming a little bit evasive. I would say maybe even a lot evasive as far as answering the specific questions asked. It's not as if he didn't do it. So just say what happened and say why you did it instead of trying to subvert the questions. The one item that came up during this piece of cross-examination that I think is really highly relevant for the jury, and the prosecutor will speak to this during their closing, I suspect, and that is, was there any attempt to render aid? People who act in self-defense, they render aid, they call 911, they do what they can to make the situation better than it already is. He did none of this. He served his own interests by cleaning up the store and then tending to his own injuries. And then ultimately, Ted, why it hasn't come up in the last two segments, the idea that you stab somebody 3 times and don't realize it is just not reasonable.
Yeah, and his take was that he had no idea that this could have actually been serious. He thought maybe he nicked him, but was shocked to find out that he died. Whether or not that holds with this jury, it will also be another question. Him going from frail, scared man, which I don't know that the video shows at all, but that was his interpretation on the witness stand during direct, to now being aggressive with the prosecution is probably not the best of looks. At one point saying, yeah, I'd take a punch back when I was 27, I'd take you out. It kind of almost like I was ready to roll my day. Well, that's kind of what we saw from him on the way over to confront the Gatorade thief.
Absolutely. He's now saying, well, I just said what I said. It had been a long commotion. 10 hours had gone by, and I was under the stress of an interrogation, which is a fair position to take. But when you take it, to your point, and look to corroborate it with the actions, it's corroborative of him grabbing a knife. If he was a frail, scared old man, there were a lot of other options than grabbing a knife and approaching someone that was literally half his age.
All right, let's get a break. We'll pick up the rest of the defendant's testimony on the stand when we return. Stay with us. Okay, there it is. The evidence is all in. The defendant taking the stand as the defense case ends up there. How did he do? Trial attorney Jamie White. We're going to have the closing arguments after a break there, and then it'll be time for this jury to decide what did you take away from it, all of it in whole. Does he have a chance here?
Well, you always have a puncher's chance when you're in front of 12 people. That's a fact. We've seen some of the most egregious cases come back not guilty, and I've seen it work the other way, where people who had a substantial amount of what court seers may see as reasonable doubt found guilty. So he has a chance. But I think the burden is extremely high for the defendant here, Ted. The instructions the jury are going to receive are going to be voluminous, but the important piece for people following this case is, before they get to the issue of whether or not a murder was committed, they first have to take into consideration whether or not self-defense was appropriate under the law. I'll be looking to see how long the jury is out. And what I would suggest is, these are always difficult to predict, but a very quick note back from the jury that they've reached a verdict would be in favor, I suspect, of the defendant. And to the contrary, if they go on for some period of time, then I think that he's in trouble. Personally, I think that this is a no-brainer. I think the standard is way too high to overcome the facts here. We have an unarmed man, a man with a knife, protecting really a property interest at the end of the day, which is not reasonable under the circumstances.
Yeah, just watching that video, I mean, he's pushing the victim in this case up against that cooler, not the other way around, as he tried to testify saying that he was being grabbed by the 27-year-old. And you look at the initial confrontation here, he is definitely the aggressor. He says that he's trying to grab the bag, they're fighting over the bag, and that is that. So we'll see. The jury's going to get it in short order after the closing arguments, after their lunch break there. We'll have those closing arguments for you and update you as this progresses.